Good afternoon, everybody, and welcome to the top 10 reasons to plan your estate. There's a few people that are still joining us, so we'll kind of just talk for a few minutes. I'm Debbie Verni. I am one of the attorneys at the Herzog Law Firm. This is the middle of webinar week. We do a week of webinars every month, and we also do webinars every Wednesday at 10 and 2. So if you want to see any more of our webinars, you can go to our website at www.herzoglaw.com, and you can register to go to any of our webinars this week, or again, they're always on Wednesdays at 10 and 2. Also, our webinars are pre-recorded on our website. So you can go to our website and you can look at what you want to see, right? So you could go on if you missed one of them and you can watch them at your leisure. I always joke and say it's like Netflix, right? That you can go on and watch whatever you want, whenever you want. So those are available to you. When we go through the slides, if you have questions, you can use the chat and ask questions, or you can actually send me an email if you have specific questions. My email address is try that again. That's the website, is dverni@herzoglaw.com. That's dverni@herzoglaw.com. Or you can give us a call at the office. The office phone number is 518-465-7581. Stacy is at extension 126 if you want to make an appointment, or my extension is 122. Again, it's 518-465-7581, and my extension is 122. So we're going to get started. Whenever we set this presentation up, this is one of our newer ones, we were thinking about something fun. So those of you that used to watch David Letterman, right? Remember he used to have the top 10 reasons or the top 10 this or that. So that's kind of how we did this presentation. We start with number 10 and we go to number 1. Now, not that they're all not just as important as the others, but again, we were trying to make it a little bit fun, a little bit different. You're stuck at home. It's kind of a cloudy, kind of almost snowy day, right? And so we thought we'd make it a little bit more fun. So we start at number 10 and we go to number 1. But like I said before, it doesn't necessarily mean that one's more important than the other. We were just trying to do it like David Letterman used to do it. Okay. So again, when we get started, if you have questions, you can go in the chat. So the number 10 reason that you want to do your estate plan, which I actually think would be the number 1 reason, is peace of mind. I laugh when people say, I don't want to do my estate planning because if I do my estate planning, then I'm going to die. Well, you're going to die anyway, so you may as well have everything in place. So whenever you have everything in place, you have peace of mind because you know that everything's set up. It's going to be a lot easier for your family to do everything after you're gone. You've given them kind of a roadmap, kind of a direction as to what they need to follow to take care of things. It's a lot easier if people put an estate plan together that gives clear direction to their family so that they're not running around wondering who's in charge, who needs to do what, where are their assets. So once you've got everything all together, it's a lot easier. You can sleep better at night. I don't know how many people have told me, wow, I feel so much better now that I have this together. And just remember, if you don't give somebody direction, all the what ifs, right? If your family doesn't get along now, they're sure as heck not going to get along after you're gone. So you really need to plan ahead and you need to give them a roadmap as to what your wishes are and how you want things taken care of. So number 10 is peace of mind. So number 9, okay, again, another reason to do your estate planning. You want to make sure that your assets are protected in case you have to go into a nursing home. I don't know how many times I've heard people say to me, it doesn't matter, or I'm not going into a nursing home. A lot of times these things happen and we really have no control over them, right? My sister-in-law always told my mother-in-law she was never going to go into a nursing home. And unfortunately, when she got to the point where she had to go into a nursing home, my sister-in-law felt terribly guilty because she's a nurse, right? But she was working full-time. We couldn't get care 24/7 at home. This is before community Medicaid was really viable. And so she ended up going into a nursing home. So her assets, they weren't protected and they went to pay for her care. So you really need to think about it and plan ahead, especially if you think you're going to have to go into a nursing home. You don't want to have to spend down your assets. And we always tell people, whether you're in a rehab, then you're going to have to go into a nursing home, or if you're looking for community Medicaid, or if you're already in a nursing home. There's always ways we can preserve assets, but we would prefer that you obviously make plans beforehand. So how much your nursing home is going to cost, right? People are like, oh, they're not that expensive. It's not a big deal. $168,000 a year is the average, right? $168,000. That's not chump change, right? $168,000. So what if you're going to go to assisted living, right? So Medicaid generally does not pay for assisted living, and assisted living could be anywhere from $3,000 to $7,500 a month. It just depends on what level of care you need. When you're in assisted living, it's kind of a la carte, right? So you go to an expensive restaurant, you order your meal, and then you want a salad, cha-ching. So I want an appetizer, cha-ching. Well, assisted living's a lot like that, right? How much can you do for yourself? Do you need help dressing? Cha-ching. Do you need help bathing? Cha-ching. So just because they give you a basic rate doesn't necessarily mean that that's the amount that you're going to pay. So you need to think about that. It's very expensive. So I'm just going to stay home. How much are caregivers going to cost to come into the house? Am I going to be able to get caregivers 24/7? These are all things that you need to think about when you're planning your estate, right? Because you need to make sure that you're going to have assets to pay for your care. And if you can protect your assets at all, then you definitely should protect your assets. So how can you be eligible for Medicaid? Okay, if you're a single person, right, you get to keep $15,900. You get to prepay your funeral, and you can put your IRAs in periodic payment status. So what does that mean? That means that your IRAs would have to be in payment status. A lot of you probably aren't 72. A lot of you aren't taking your required minimum distributions. So that is what the nursing home is entitled to, right? So the IRAs, 401ks, all those are protected in New York if they're in payment status. So if you've put them in payment status and you're taking the required minimum distributions, that money is going to go to pay for your nursing home, but the principal of the IRA is going to be protected. So you get to keep a whopping $50 a month, right? So they're going to take your Social Security, they're going to take your pension, they're going to take your RMDs. You're going to get a whopping $50 a month so that you can pay for your getting your hair done or playing bingo or whatever. So again, not a lot of money, and it's not $15,900 a year. It's not $15,900 a month or a week. It's $15,900 for the rest of your life, right? No house, no boat, but you actually can keep a car of any value. So that's another planning thing that we use a lot of times. So what if you're married? Okay, so what if you have a spouse in the house? With all the stuff about Dr. Seuss right now, I probably shouldn't be talking about Dr. Seuss, but this is the rhyme that you will remember from today. If you have a spouse, you keep the house. So if you have a spouse, meaning a spouse that's living in the community, they can keep up to $130,380.50. Again, I don't know where they get these numbers. They get to keep a house as long as they're living in it, and they can prepay their funeral expenses. So if you got the max, let's just say you got the maximum between the two of you, you get to keep like $145,000. You could prepay your funerals and have a car of any value between the two of you and a house. So it doesn't sound too bad if you have a spouse, but then comes the income situation. The spouse that's at home, the community spouse, gets to keep a little over $39,000 a year. So if the spouse that's going into the nursing home makes more money, they're going to give them a piece of their money, right? So if I'm going into the nursing home and I make $40,000 a year and my spouse only makes 10, they're going to take 20, 25 from mine, give it to them so that they make at least $39,000, and then the nursing home is going to take the rest of it. So what's an alternative? An alternative that we talk about a lot when we do our presentations and when we talk to people are asset protection trusts. They're called irrevocable trusts. They're called Medicaid trusts. They're called asset protection trust. They're called a lot of things, but basically they are trusts that protect your assets. So think of an irrevocable trust as a box with a lid on it, right? You put your assets in there and it's got a lid on it. And because it has that lid on it, you can't reach in and write yourself a check anytime, right? So you don't have to write the nursing home a check. So those assets need to be in that trust at least 5 years before you're looking for care in a nursing home. People are like, well, why would I want to tie up my assets like that? Well, you're not really tying them up. you get to appoint the trustee and you get to name who the beneficiaries are. And if the trustees and beneficiaries don't do what you want them to do, you can always change them. Also, you will still get all the interest and dividends from the accounts. And you also can buy, sell your real property, right? The trustee just has to sign the contract. That way your assets are protected. Whenever you pass away, you avoid probate because the assets go out to your beneficiaries. Sounds too good to be true, right? Also, if you needed to take money out, so let's just say that I put all of my money in my trust account. By the way, you can't put retirement accounts in your trust. But let's just say I put all of my money in my trust, and then all of a sudden I needed money out of my trust because I sold my house, all my money went back in the trust, and now I want to live in these really, really nice senior apartments. You can do what's called a partial revocation. You can kind of chip off a piece of the trust, kind of think of it like a piggy bank, right? So you have a piggy bank, you pop off the bottom, you shake some money out, you put the cork back in the piggy bank. The assets there in the piggy bank are still protected, but the money that came out is yours to spend however you want to, right? So you can pay for a nice trip, or you can go out of town. You can do whatever you want to. But to do that partial revocation, you have to sign off, the trustee has to sign off, and the beneficiaries have to sign off. And what if they won't? Well, like I said before, you can fire them. Classic example, and those of you that have heard me speak before, I always give an example of Harry's client who wanted to go to Italy because her sister was dying. Again, this is pre-COVID, way back when. And whenever she said, I need to take $20,000 out of the trust, we prepared the paperwork. We sent it out to the 3 daughters. It came back from 2. The 3rd daughter, we said, hey, did you get the paperwork? Well, yeah. Well, are you going to sign it and send it back? She's like, well, mom's old. Like, me signing this is like taking money out of my own pocket. To which we said, hey, if you look at Article 9, it says she can change the beneficiaries anytime she wants to. So if you don't sign off, we take you out as a beneficiary. Mom gets her money, and we'll see if she puts you back. Next day, Federal Express, we got the paperwork back. So you're really still in control, and you're protecting your assets just in case you had to go into a nursing home. So number 8, avoiding probate. People are like, oh, probate's not a big deal. I have a will. Okay. Wills control assets that you have individually in your name. What that means is if everything you have is joint or has a beneficiary or it's in a trust, it's going to avoid probate. Therefore, it doesn't have to involve the courts. The executor doesn't have to be appointed. The assets can just simply go to the person they were supposed to go to. Now, probate is not a big deal, really, if you have, say, a nuclear family, right? The issue we had the other day when I was meeting with people and they were trying to decide whether they were going to do a trust or not, was that if she passed away, which everybody's going to pass away, if she passed away, even though she had written out her brothers and sisters, because she doesn't have a spouse, because she doesn't have any children, because her parents aren't alive, they would have to receive notification, even though she'd written them out. She's like, well, I don't even know where they live. And I said, well, then that's why you should do a trust, so they don't have to notify your next of kin. I always use for a classic example the fact that Mary Lou Whitney, right, from Saratoga is elite. When she passed away, they had to probate her will. And there was a lot of information in the paper, right, because it becomes public record about her kids and how she didn't treat everybody equally and how she gave money to different charities and stuff like that. Well, if she'd had a trust and hadn't gone through probate, then that information would not have been public. And what's it worth, right? What's your privacy worth? So we want to avoid probate. We want to make sure everything's joint, has a beneficiary, or is in a trust. So when I was talking about wills, the wills have to go through probate. Just because you're named executor in someone's will doesn't mean you can walk into the bank and close out their account. So we have to file a petition with court. The court has to validate that it's a valid will, validate that everyone got appointed, that everyone got their waivers, everyone signed off, namely kind of like when I was talking about this woman, her family would have had to sign off. They're going to appoint the executor, they're going to name the trustee, and again, wills become public. So if you're kind of nosy and you want to know what's going on, if your neighbor passed away and you know their will had to be probated, you can go down to the surrogate's court and you can find out who got what and how much they had. So better off to keep everything out of probate. Again, joint, beneficiaries, or trust. So when I was talking about joint beneficiaries or a trust, right? The will only controls assets that are individually in your name. So if you forgot to put a beneficiary on something, or the beneficiary that you named passed away before you, it could end up payable to your estate. That's why you need to make sure that your beneficiary designations are up to date, and you need to make sure that you have contingent beneficiaries in case something happened to you and your first beneficiary, for instance, husband and wife, right? Something happens to both of you at the same time. You want to make sure that you have a backup beneficiary. So beneficiaries on life insurance, beneficiaries on retirement accounts. You can go into banks and you can put beneficiaries on your checking or your savings. They're called transfer on death accounts, TOD accounts. You can go in and do that. That way, whenever you pass away, all those assets are going to go to your beneficiaries. We don't have to probate your will. You save a lot of money on the back end, right? Sounds good. So 7, providing for special needs children. There are a lot of people that have children that have special needs. And there's a lot of people that have grandchildren that have special needs that they want to make sure that the child is taken care of. In the past, whenever a lot of people did estate planning, they would just not leave anything for the child that had special needs, right? So they would just leave it to their brother or sister and say, hey, by the way, you need to take care of your sister. Well, that's all good and fine, but you need to realize that when you're leaving the bulk of your estate to one child and say, hey, by the way, take care of your special needs sister, that they don't have to, right? Even though they've got all good intentions, what if they pass away, right? Then that money's going to go to whomever their beneficiary is, and they may or may not take care of the other person's sibling. Or what if your child has financial trouble, right? So his creditors don't care whose money that was supposed to be. They're going to come in and take it. So you really need to think about this whenever you're trying to set up estate planning. And one of the things people will do whenever your parents or grandparents is you can set up what's called a third-party supplemental needs trust. Okay, so a third-party supplemental needs trust means it's set up by a third party. So parent, grandparent. I was meeting with people the other day and I was telling them that if they don't want to set up the trust now, that they could set up the trust in their will, right? So let's just say we've got 2 kids. We've got a son and a daughter, and we have a daughter that has special needs. So we say when the last of us dies, 50% goes to son, 50% goes to daughter in a trust, right? And then we make the son the trustee, we name a backup trustee, and then that way that money can go to the daughter and it can pay for things for her. And it's not the son's money, and he doesn't have to worry about creditors or anything else, but he would be able to be trustee and pay for expenses, pay for housing, pay for all kinds of different things for the child or grandchild. And again, this trust is not set up sometimes until the person passes away, because a lot of times whenever you have a child that has special needs, you take care of them while you're alive, and you really need to think about what's going to happen to them whenever you pass, right? Where's the money going to come from to support them and take care of them? So that's what this is kind of talking about. So how can you spend the funds in a supplemental needs trust? I always tell people that the money in the trust is there to supplement, not supplant, meaning anything that they're getting, Medicare, Medicaid, SSD, SSDI, whatever they're getting, right? The trust can't pay for. So in other words, I have to go to the doctors and my Medicare pays for that. Well, then the trust is not going to pay for it. Well, what if I need to go to a specialist in New York and Medicare or Medicaid won't pay for it? Then my trust can pay for it. My trust can always pay, can also pay for vacation, right? I can go on vacation and the trust will pay for me and pay for someone to go with me. I can get a new bed, but I can't have direct cash. So I can't go to my trustee, hey, I need a new bed. Give me a couple grand. I'll go over to the furniture store and buy it. What's going to happen is I'm going to go to the furniture store, find what I want, and call the trustee, and the trustee is going to have to pay the furniture store, right? You can't give the person cash. Just remember that. You can't make any cash distributions. You can pay for a lot of stuff, but you can't make cash payments to the beneficiary directly. So number 6, this is kind of an important one, and a lot of people really don't think about it. Excuse me. What about kids from a prior marriage, right? And people are like, well, why is this such a big deal, right? So second marriage, third marriage, husband dies. So let's look at this. Here we go. We'll do something fun. So I guess we don't get to do the whole David Letterman thing. Let's do Brady Bunch, right? So I know you guys, some of you are like, Brady Bunch, did I see that show? And other ones are like, yeah, Brady Bunch. So he has 3 boys, she has 3 girls, they get married, right? So they get married, and there's rumors. If you talk to Dave in my office, he'll say that, they adopted each other's kids, but it never came out in the show. So I don't really know if they did or not. Most times they don't. So let's just say they didn't adopt the kids, right? So let's just say that Carol Brady was the wife with the 3 girls, right? So she passes away and she leaves everything to her husband. Okay. And then the husband ends up marrying Alice. Okay, go ahead, laugh. Alice was the maid, right? Alice helped out around the house. So now Mr. Brady married Alice, and now he and Alice had a child, right? And then he dies and leaves everything to Alice. And then Alice leaves everything to her child, Sam, of course, right? Because remember, she used to date Sam the butcher. Anyway, so Alice dies. Who gets all the money, right? Sam. It's not going to go to the boys. It's not going to go to the girls. It's going to go to Sam because that's her child. So you really need to think about that, because a lot of times whenever people get married, second marriages, it's kind of like last man standing wins, right? The husband passes away, leaves everything to the wife. And then the wife gets into a tiff with the husband's children. And guess what? They're out of the estate plan. Everything goes to her kids. So a lot of times what we'll have to do is we'll have to set up what's called a spousal trust. That's for the benefit of the surviving spouse, and then pays out to the children after the person passes away. There's lots of different ways we can protect children from prior marriages. We just need to know the information, right? We need to know that there's kids out there and we need to protect their inheritance. So it's a lot of things you can do just to make sure that you don't disinherit your own children. So number 5, planning for minor children's inheritance. Kids aren't very good with money, right? Sometimes adults aren't very good with money, but the thing you need to think about is, how are your kids going to deal with money? Obviously, if they're under 18, you do not want to make them a beneficiary, and you never want to make a minor a beneficiary on an IRA. Those of you are going, well, hey, there's a stretch IRA. By the way, they don't have stretch IRAs for beneficiaries anymore. They have to take it over 10 years. But in the past, people were like, hey, beneficiaries on my IRAs get to stretch it over their life expectancy. So if I leave it to a 5-year-old, look how far they can stretch it. Well, number 1, 5-year-olds aren't very good with money. And number 2, if you leave money to a minor, that's an IRA, for instance, they have to have a guardian appointed for them before they can collect the money and set up a beneficiary IRA for this child. You're like, but no, they have a parent. It doesn't matter if they have a parent. We still have to have a guardian appointed if they inherit money like an IRA. So let's just say you leave it directly to a child and it's not an IRA. You just leave them a checking account, right? Then they're only going to be able to keep that money away from them until they're 18. 18-year-olds generally are not very good with money. There's some that are. Those of you that are thinking, not my kids. My kids are great with money. They may be really good with money, but maybe their friends aren't. I remember whenever my son went to college, the very first year, the favorite guy at college was this kid that just got a big settlement from a paintball accident. And guess what? After the first year, all of his money was gone. And because he partied and spent all of his money, he was the favorite, right? He was the one with the car. He's the one that had all the friends. And after the first year, all of his money was gone. And guess what? He didn't qualify for a scholarship in year 2. So guess what? No college. So you need to think about these things. You need to protect your children from themselves and protect their money. So whenever you're planning, you got minor kids and you're doing your wills, you really need to set up a trust under your will for the benefit of your kids. Usually kids, grandkids, the minimum age I give money, like big sums of money outright to kids, is 25. I'm hoping by 25, they're out of school. Maybe they're in their first job. Then they need that money to pay off their student loans and stuff like that. But generally 25 is a good age to have money go to kids. So these are things that you really need to think about. If you're going to leave money to kids, you're going to leave money to grandkids. You want to make sure that they're mature enough to spend or not spend the money, right? So what about guardians, right? So you have young kids, and I've been doing a lot of estate planning for young couples, right? That are just having kids. They've got minor children. They need to think about it. So who's going to raise the kids, right? Who's going to take care of them if you pass away? oh, it's not a big deal. Nothing's going to go wrong. We're young. Yeah, you might be young, but you need to realize that anything can happen. So when you're doing your will, if you have kids that are underage, you really need to think about who's going to raise them, right? And who is going to take care of their money, right? Who's going to be their trustee. Even when I have people that are divorced, right? And they're like, well, if I pass away, my husband's going to end up with the kids. Well, what if he's not, right? What if you have custody and you pass away and he's like, no, I don't want the kids full time. I don't want to be their full time parent, right? Who would you want your kids to live with? So I always have people appoint a guardian, even though we know by law they would go to the other parent. And I always tell people that they need a guardian and they need a trustee, and they may not be the same person, right? That way you have checks and balances. So if you got one person that's taking care of the kids and the other one that's taking care of the money, you'll have checks and balances so that you make sure that the kids' money doesn't get spent on silly things, because this is all the money these kids are ever going to have, right? So think about it. Who's going to support your kids, right? Who's going to be the trustee, and who's going to take care of the kids? Who's going to raise them? And these are all things that should go into your documents. So number 3, okay, choose your beneficiaries. This seems like a really simple one, but if you don't choose your beneficiaries, the state of New York is going to choose your beneficiaries for you, right? So if you don't have a will in place, if you die and you have assets individually in your name, then we would have to do what's called an administration proceeding. And when you do an administration proceeding, you have to look for next of kin, right? And that's who's going to get your money. So if you want to make sure that you say who gets your money and who you want to be in charge, you really need to do a will, and you need to name someone as executor, someone as trustee, and you need to name your beneficiaries. So whenever you pass away, if you don't have a will, what the rules are is it's the rules of intestacy. So what that means is they look to see who you're survived by. So if you have, they look to see if you have a spouse. If you have a spouse and no kids, it's all going to go to spouse. If you have kids and no spouse, it's going to go to the kids. If you have kids and a spouse, then the spouse gets the first $50,000 and half of the rest of it, right? No spouse, no kids, goes to parents, no parents, brothers and sisters, nieces and nephews. It goes all the way down to first cousins once removed. We always joke and say they take a brick and whoever's head it falls on when they drop it, that's who gets your money. And that sounds kind of silly, but it really is. If they can't find a first cousin once removed, then guess where your money goes? Yep, the good old state of New York. So you want to make sure that if you have specific places that you want your money to go, that you set up a will and you name your beneficiaries. A lot of you are still looking at that first line where it's like, wait, so 50,000 to my spouse and then half? Yeah, that's right. I had a situation one time where I didn't do the estate planning. We had a gentleman that he had a job where he could get sued. So he deeded the house just strictly to his wife. And then she passed away. She didn't have a will. So the house would go, first $50,000 goes to him, and then half of everything else goes to the 2 kids, which you think is not a big deal, right? Except for the daughter decided she wanted her money. So the son's like, no. This is dad's house, right? It's mom and dad's house. What makes you think that you should get a percentage of this, right? He's still alive. And she's like, no, law says I get my piece. And she actually took her father to court, and she ended up getting her piece of the pie. I mean, does this happen a lot? Families? No, but you really need to think about these things and make sure that you have documents in place. I just had an estate that I did where the husband passed away and he didn't have a will, and everything's going to the wife because the son is signing a disclaimer. Basically, he's saying, I don't want any of the assets, give all the assets to mom. Well, that's a good thing, but it's a lot of paperwork, a lot of going through the courts. You could save you a lot of time, a lot of grief just by doing a will and or doing a trust, so you don't even have to go through the courts. So number 2, and now we're getting down to the nitty gritty, right? Loss of capacity. You need a power of attorney. I always say that a power of attorney is the most important document. And the reason that's most important is because if you get sick, right, and you have to go to the hospital, usually they're going to look to your next of kin to make your healthcare decisions. If they don't, if they are fighting, right, then they'll make a decision for you. The nurses and doctors will make a decision for you. If you don't have a will, I just told you how that goes, right? For the intestacy laws in the state of New York. If you don't have capacity, right? If you can't make decisions for yourself, there's no one that can do that for you. You need a power of attorney. If not, we would have to do what's called a guardianship proceeding, right? So even if you're married, they're not going to let your spouse sign off on things, right? So say you were incapacitated and you were in a nursing home and they were going to try to sell your house. Not going to happen, not unless they have a power of attorney. And no power of attorney, we have to do a guardianship proceeding. And that's something you definitely don't want to do. It's very, very expensive, very, very invasive. So power of attorney, what kind of document is it, right? So you are the person that's setting it up. And then you name an agent. An agent is the person that's going to make decisions for you. So the person who is signing it, so say I'm setting up a power of attorney, I have to have capacity to sign. No one can do it for me. If I don't have capacity, then I'm not going to be able to sign the power of attorney. And the agent is also going to have to sign. So whoever I've appointed has to sign the power of attorney or they're not going to be able to act. You don't necessarily have to be in the same room and sign it together. A lot of times people will come in and sign their power of attorney and then we mail it out for their agent to sign. It has to be notarized. The powers of attorney, since 2009, they changed them. The powers of attorney with the statutory gifts writer are about 13 pages long. It's very difficult to do one. Before that, it was fairly easy. Anybody could do one. But since 2009, it's very difficult to do a power of attorney. I would never suggest that someone just download one online and do it themselves. Lots of places to initials, lots of places to sign. And it's really the most important document that you can have because these are all the things a power attorney can do, right? So I always joke and say, the person that you've appointed, kind of like the old song, anything you can do, I can do better. Well, they can't, right? They can open accounts, close accounts, change names on accounts, change beneficiaries on accounts. They can sell real property. They can call up your insurance providers, get information. And that's the big thing too. I mean, we're going to talk about healthcare proxies. Oop, I gave away the first one. Anyway, healthcare proxies can only make healthcare decisions. Power of attorney can only make financial decisions. So the power of attorney is the one that's going to be able to get your medical records, talk to the insurance company. Hey, is this covered? Do we need a second opinion? Healthcare proxy is the one that's going to be talking to the doctors. So again, the power of attorney is the most important document that you can have. But a power of attorney can't sign a will, and a power of attorney can't sign a healthcare proxy. So you need to make sure that you have all of your documents. So statutory gifts writer, that's what I was talking about before. If you don't have a statutory gifts writer, the person that you've appointed is limited in their gifting power. And you're like, why do I care about that? Why would I care about gifting? Back to the husband and wife thing, right? So husband and wife own a house jointly. He goes into the nursing home and he's gone. He has no capacity whatsoever. And she's going to sell the house. Well, he's not able to sign off on the house. He's not able to sign off on the deed, right? And if we want to get him on Medicaid, we're going to have to transfer that house to her. And she's not going to be able to sign the deed on his behalf unless she has a power of attorney and unless it has a statutory gifts writer. Because without a statutory gifts writer, the most a person can gift is $500. And theoretically, she's transferring half of the house to herself. So when doing a power of attorney, you're really cheating yourself if you don't do a statutory gifts writer. So if you're meeting with an attorney and they say, well, let's just do this simple one, it's not worth the paper it's written on. You really need a statutory gifts writer on your power of attorney so that you're giving the power of attorney, the person, agent, all of the power to be able to do everything that they need to do. Also, you can revoke your power of attorney anytime. And whenever you pass away, your power of attorney ends when you end. A lot of people don't realize that, and they have their power of attorney on their checking or their savings, and they think after the person passes away, they can just go in and close the account. Nope, they can't. Whenever you die, the power of attorney dies with you. And so if you don't have a beneficiary on that account, they're not going to be able to get in and get that money. So the number one reason to plan your estate, drum roll, please, right? So medical directives. What kind of medical directives do you need? Healthcare proxy, living will are two of the major ones that you want so that you have a person in place to make healthcare decisions for you. Living will, so you can tell people how you want to be treated at end of life. Um, some people are too young to remember the Terry Schiavo case, right? Where the husband was fighting with her parents. He was saying she would never want to live that way. We need to pull the plug. Her parents were like, no, 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 she has a chance. We want to keep her on artificial means. And she had no ability to make decisions for herself, right? So you really need to have just a simple healthcare proxy that says who you want to make your decisions for you. And you need to also have a living will, which is your end of life decisions. So healthcare proxy, you have to have capacity to sign. You have to be at least 18 years old. You sign it, and then you have two disinterested witnesses that sign it, meaning anyone that you've named in the healthcare proxy can't be one of the witnesses to your healthcare proxy, right? So whenever we execute them, we have two witnesses that sign them for our person. So living will, which is what I was talking about before, living will is end of life, right? When the doctor comes out and says, hey, they're not coming back, give me good drugs and let me go. Do you have specific things that you want? You really need to talk to the person you appoint, and you need to make sure that that person is going to be able to follow your wishes, right? So if you don't want to have CPR, if you don't want to be resuscitated, if you don't want to be on a feeding tube, you need to make sure that the person that you talk to, right, the person that you appoint is a person that's going to follow your wishes. Because just because you said, oh, I don't ever want to live like that, you need to put your wishes in writing, because unless they're in writing, they're going to look to them to make decisions for you, and they're not going to know, right? What you need to also know that is a living will really doesn't have any teeth. What that means is, let's say my living will says, I don't want to be on a feeding tube, or I don't want to be on a respirator. And they come out and they say to my person, she's doing really well. We think she'll come out of this. She needs to be on a feeding tube and a respirator for a couple of weeks, and then we'll be able to wean her off of them. At that time, even though I've said in my living will, that's not what I want, they're still looking to that person to make that decision. And they could say, I've seen her come back from harder than this. I think she's going to be fine. So yeah, let's do it. Okay. So need to make sure that the person that you appoint knows what your wishes are and they'll follow them. So this is your summary, right? This is your top 10 summary. If you want everything to be protected and you want everything to go where you want it to go, you need an estate plan. If you don't plan, a lot of your hard-earned money could go to pay for your care, go to pay for a nursing home. It could go to those, as they call them, shirt tail relatives that you don't want it going to. It could disinherit your kids, not on purpose, right? Or you can disinherit your kids on purpose. Just remember, when you're doing your estate plan, you can disinherit anyone you want to, except for your spouse. In the state of New York, you cannot disinherit your spouse. Okay. That being said, you can disinherit anybody else you want to, but you really need to put that language in there, or your money, based on the laws of intestacy, may go someplace you don't want it to go. Something to think about, right? Also, do you really want the courts to decide who's going to take care of your kids or who's going to be the trustee for your kids? I don't think so. You really want to be the person that makes those kind of decisions. And you never know. You absolutely never know what's going to happen, and you never know what's going to happen to your family. And if you have, kind of going back to the first slide, right? If you have a proper plan and order, it's going to give you peace of mind, right? You're going to know things are going to go where you want them to go. And you're going to know that people that you want to be in charge are the ones that are going to be in charge. And don't choose people based on, okay, I have 2 kids and he's the oldest, so he's going to be the executor and the trustee and the power of attorney and the healthcare proxy. Give people jobs based on their skill set. If you have one child that's better than money, or one that's a healthcare person that you know will follow your wishes, name the healthcare person as your healthcare proxy. Name the other one as your power of attorney and executor. Not everybody wants these jobs. When people say, hey, who should I choose as my executor? I'm like, someone you don't like, because it's not a really fun job and it's really a thankless job. So again, put your plan together, whatever it consists of. It should definitely consist of a will. a healthcare proxy, a power of attorney, and a living will. Those are the major documents that you need. A trust, if you're trying to avoid probate and you're trying to avoid your money going to the nursing home and protecting your assets and protecting children from a prior marriage, generally a trust is the way to go. So those are all different things that you need to think about. So last but not least, we do offer free consults. We are open. We've been actually in the office since June. So we are doing appointments in person in one of our 4 offices. We have an office in Kingston. We have an office in Clifton Park. We have one in Saratoga, and we have one in Albany. And the one in Albany is where I am today. But we can meet with you at any of the 4 offices. We also do Zoom consultations. We've been doing a lot of those with COVID, and we do phone conferences. So whatever works for you, you can set up an appointment to come in or just talk over the phone. We do estate administration after someone has passed away. We also do Medicaid planning before somebody has to go into a nursing home, or we do planning afterwards. So if there's someone that's in a nursing home and we're trying to preserve some of their money, we can do that. We can also do community Medicaid, which is Medicaid at home. That would probably be the aging in place webinar if you want to know more about that. I think that one is maybe tomorrow. You'd have to check on the website at www.herzoglaw.com. And also, if you have any questions, you can email me at dverni@herzoglaw.com, or you can call us at 518-465-7581. You guys will be getting a copy of these slides to your email address after the presentation. It may take a couple of days. And also, if you're like, wow, that was a lot of fun, we have a radio show every Saturday that's on Magic 590. It's live. It's from 8 to 9 a.m. You can call in, you can ask questions, or you can actually just listen if you want to listen. There's a lot of good questions, a lot of good conversations on the radio. And again, if you've missed any of the webinars, you can go to our website at www.herzoglaw.com and watch them at your leisure, or sign up for some of the new ones. Like I said, this is the first time we've done this one, so it's not on the website yet. It will be, but it's not currently on the website. So I appreciate you hanging out with me today, and I hope you got some good information, and we look forward to seeing you in the future. Take care.